Good evening, friends. And once it was a Sunday, and I requested Mr. Jawad to you do a lot of meditation as well as mediation. We will not talk about meditation as such, but definitely we will talk of mediation. And that too, at least a lot of people do have a notion within them as to whether there is any sanctity of a private mediation, what is the role, and though it's not related as to whether one can make a career in a private mediation. Though we had resource persons, Mr. Atul Lakhanpal, a senior advocate, a senior trainer and a mediator of Punjab and Haryana High Court. And though he has his recognition not only in India, but beyond that, just like a virtual world and today's webinar, he's acknowledged everywhere. And same as with Mr. Jawad, those who are connected on the social media, you'll find Mr. Jawad. He may talk to you privately, but he's publicly known figure. And therefore, we thought that public mediations and public sector mediations are always, we are talking about, why not talk about private mediation, not in a private place, but open in a public place. I will not take much time because we have amongst us also Varuna. Again, I can say that I'd heard that dots do make line. And if they are meaningful persons, they make a line in a positive direction. I will ask Varuna to share her thoughts, and then we'll request Mr. Jawad and Mr. Atul Lakhanpal to take the sessions forward on a Sunday evening when people have kept their time for the private time for the family. But during that time to chip in, not for the tea, but chip in for the knowledgeful gaining of private mediation, its sanctity, etc. I'll ask Varuna to share her thoughts and then over to them.
To begin with, thank you, Vikasji, and very well said. Atulji and Jawadji are not limited to the country, but they are world over, very, very prominent with their training abilities and their mediation abilities and meditation as well. Coming to the topic of private mediation, so I would say that that is the future of dispute resolution. And by future, I mean to say that we have already worked toward it for last couple of years. And in private mediation, I feel that we have the support of Arbitration and Conciliation Act. And when either of the parties approaches a mediation center or a mediator office, they can propose like a KISOC that, you have come to us and there are, in your matter, there is a possibility of a faster, adjudication of the problem. So instead of going for litigation, maybe we can try mediation. For that, appropriate office or a center, which is well reputed. We do have a court annexed pre-litigation mediation center also, where you can put in an application on behalf of that person and go for the other side. So that is when there is where then there is a lawyer who's working as a KISOC and is directing a party to go for mediation first, because he is giving him an option of litigation as well as mediation and benefits of mediation. He explains to the person. So the person has to move an application, and the application, if it is a court annexed, there will be I'm just talking of the process. There will be a notice sent to the other side, and they will be asked to appear before the center along with their lawyer. Once the parties are there and a mediator is allocated to them, the mediator will make an opening statement. If the parties are willing to participate or want to try mediation before they have gone in for litigation, or even if there is litigation going on, yet they want to go in for mediation for faster adjudication. So they can ask the center to go ahead with it. And even if they have gone to any organization which is providing mediation, and they have made an application, presently in my office, we are taking the benefit of Arbitration and Conciliation Act, and we send a notice to the other side. And once the other side comes, a mediator is allocated. The mediator makes an opening statement. If the parties are willing to go ahead with it, the process of mediation is followed. And after the process is followed, the settlement award, there is a tripartite agreement between the mediator and the two parties, or maybe more parties. And in that, the rules of mediation are laid out. The parties accept the fee structure, they accept the rules, and they accept that the outcome of this mediation will be a conciliation award, which itself is a decree under the Arbitration and Conciliation Act. So this is like, I'm just explaining the process. I don't think we need a separate mediation bill. That is my take on it for taking the private mediation forward. Rather, we are well equipped with our knowledge of mediation process, and with Mediation and Conciliation Act on with us, we should be able to do private mediation in a very big way. But the only thing is, we are missing out on awareness programs about mediation, how mediation can be helpful in the private sector, and how to go to those mediators or those organizations which have well-trained mediators with good facilities to provide these the facility of mediation. With that, I think I can leave the discussion to go on.
Thank you.
So,
Because you are muted.
I thought that once the ball is in your game, I will not. You will take over, both of you. Yeah. Mr. Jawad, you give an action, then Mr. Lakhanpal will give the insights.
No, yeah, I think he's he knows that I can't speak so well as he does. So it's better I speak first, so that some people listen to me also. After Jawad speaks, I will be irrelevant that way.
No, not at all.
Just a minute before we take the session.
In fact, they were both comparing me with Jawad. I think they are doing it very wrong, because Jawad has been our teacher. He has taught us mediation. He has held our advanced training. So I don't compare myself with you, Jawad, in any way.
I think you're just being kind. You're just being kind. That's all.
No, not at all. It's a heartfelt feelings I have for you. We have learned so much.
Atul, you will give probably, at least I feel that private mediation has not kicked off in Punjab Haryana High Court to that extent the way it should be. Not High Court, I will say, in this area as such has not been kicked off, wherein people do feel that it is a necessity, but be that as it may, and that is why probably this session is primarily to sensitize people on this issue.
Yes. So the topic is value of mediation and sanctity of mediation. That's what I've been told by Vikas. For understanding the value of mediation, I must relate to you two small anecdotes, which will actually explain the value of mediation. It's a small joke kind of a thing. There was a case going on. The case was decided by a judge. The lady stood up and said that justice has not been done to me. The judge said, yes, I know justice has not been done, but I have just cleared my file, cleared my table. That's it. If you say in Hindi, they say, इंसाफ नहीं हुआ. कहता मुझे मालूम है, मैंने सिर्फ मेल साफ की है. So this is the situation today. So if you are in court, you will never get justice. But in mediation, once two people are there deciding their future themselves, I think justice is done in mediation than in any other court in India or anywhere else. That's what my take is on mediation. The second I'll tell antidote, which has happened with me also, and I think it will be happening with anyone. We were in mediation center in Punjab and High Court. One of the judges comes and says, how do you do mediation? I told him the process. Then you must be threatening all the parties also. That if no, Micah, the only threat we issue to the court, to the parties is, if you don't settle here, go and suffer for 30 years in the courts. Honestly, I put in more than about 40 years in practice. But today, I can't even honestly tell my client and in what time I will get you justice. If not justice, will the case be decided? Will it be decided in his lifetime? Lifetime, I'm not saying uncertainty of life, but general expectancy of life, I'm saying.
No.
Can we actually say with our hands on hearts that you will get justice or the case will be decided in your lifetime? I think the answer will be no, if honestly. If we get through the trial court and the first appellate court, then we have bottlenecks in High Court, then the party goes to Supreme Court. I think in our part of the country, we have litigation pending for last 32 for 35 years in civil case matters and 40 years, 20 years in criminal matters. So I think the value of mediation is clear from the fact that all the people are trying to jump into mediation bank, and especially the honorable judges are also not trying to become mediators even after retirement. I don't want to comment what Shriram Ponchu has held, but somehow I agree with him. Let's leave something for the lawyers too. To my mind, the judges can never become good mediators because that cap never goes of authority. And in mediation, we have to remove that cap of authority. Only then we can actually do mediation. That's what we have been taught by Jawad. Am I right or wrong, Jawad?
Absolutely right, sir.
So there are little things which are troubling people. That what is the sanctity of private mediation? Well, private mediation, if we settle the issues, there is a provision under the Arbitration Act, Arbitration Conciliation Act, Chapter 3, where it can become an conciliation award. It can be enforced as per the award, as per the conciliation award. It can also be kind of being done in this arbitration proceedings also, which they say that it can't be done. I think even mediation can be done in arbitration proceedings also. If they, I think it's a very prenatal stage, I will say, very where we are actually hoping to go in a big way in private mediation. The people are not actually sanitized about the mediation process, and the mediation whether it can be binding amongst the people, or there can be pre-litigation mediation, or if they go for mediation, whether they can actually go to the courts after that. I think they're all misconceptions, a lot of misunderstandings amongst the people. So they're not choosing private mediation as such. I think in both ways they are wrong. I think mediation can be done pre-litigation and after the litigation also. After the court's private litigation, there's no bar. In court annexed mediation, yes. In pre-litigation mediation, they say unless you have been to the courts, unless you have not been to the courts, only then you can come in pre-litigation. That's what our rules say. But I think even private mediation, as a private mediator, there's no bar. Even if the courts, the case is pending in the courts, in the High Court or Supreme Court, they can approach a private mediator and come into the settlement. That's what my understanding of law is. Once we are a private mediator, there's no bar in it. Well, and then a lot of, I was just going through, though there was no light, so I just they're going through many documents which I have found that even in it is also enforceable under the Contract Act. It can be taken as a contract and enforceable. And even if that happens, and that happens in very rare circumstances when the party backs out of the contract, but the very spirit of mediation, if the mediation has been done in the real spirit of mediation, and when both the parties have agreed to all the terms and conditions, and once they have understood whatever is, there are very rare chances of parties backing out of mediation. I have seen very few cases where the parties get misguided by some lawyers or some people to back out of the settlement. Otherwise, there is no way. And I said, it's in the, this is an enforceable right. It can, even in this this Consumer Court Act, there is a provision now for even in this commercial act, they have introduced this, so 12A, 5 of the commercial acts, they have made it mandatory and it can be enforced as even 34B, 34 of the Arbitration Act. It can be enforced under the 36 of the Arbitration Act. So there is no bar, no difficulty in getting it enforced. The sanctity of mediation as such is well recognized even without the bill. So the only thing is the push needed for private mediation is, in your part, in Varuna's place, there are people who are in private mediation. But unfortunately, in our part of the country, there are none. If there are, but then they are not significant enough to make so many dent in the entire process. And still, there is no person who has actually taken up the private mediation here. So the sanctity wise, I feel even before the codified law was there in India, introduced in India, we had this panchayati system which is akin to mediation, which is we have in fact very old history of mediation. Those people acted as mediators. But now we can't expect sarpanches now or punches who are elected people to be impartial in any way. We can't actually expect them. So we ought to have some mechanism even for private mediators and some authority controlling this private mediation. Otherwise, one black sheep can ruin the entire process, and the entire private mediation will go for a long. That's why I don't. Something has to be done about that also. I see some hands standing. If there's some question, there was one person who wanted to ask something. I don't know. Anyway, so that is my take on this subject. Dharmendra is, I think, is raising hand.
If I may suggest something, sir, can we keep the questions to the end?
Yeah, that's it. So that is what I'd like to say, that the value of mediation today is more relevant today than in any century, because we have been bogged down by the procedural laws. The procedural laws are not giving us justice anyway. Half of the law reports are based on interpreting the procedural laws. I don't know how the procedural laws decide the fate of a person, and it takes years and years to decide what has been said and not said in the pleadings. In mediation process, I think it's all accepted and acted upon, and that's very good thing about mediation. That's what I want to say. Over to you, Jawad.
Thank you very much, sir. I think you gave quite a good overview of what the topic is all about. Now, and also for being so kind as to accommodate my request to start, and also for the very generous things that you said about me. I don't know whether I deserve all that, but I'm very grateful to you for making me feel important. So thank you.
You deserve more. I am little miser with my words.
Thank you, sir. And I also acknowledge the presence of Mr. J.P. Singh, senior advocate here, who's also been my teacher at one point of time. And I still.
He's been our teacher also. In fact, we learned from him.
Exactly, yeah. So just coming back to the topic, first of all, thank you to all of you who have joined today, because when Vikash asked me yesterday, I was wondering, it was totally done at a very short notice, because yesterday morning he called me and said, can we have a talk in the evening tomorrow? And because I was expecting some guests in the evening, I said, can we have it instead of your usual time, can we have it at 5? And he readily agreed to accommodate me. And I was wondering on a Sunday evening, how many people would really feel interested to, take time off their weekend and come and sit here and listen to me. So, but really good numbers I hear. Thank you so much for all of you for joining. Now, I understand that there are people who are new to the concept of mediation, who don't know what mediation is all about. So Atulji has also already given us sort of an overview of where we stand today, what is the sanctity of private mediation. Let me just start by talking to you about what is mediation. Mediation, when there was a point of time when I used to tell people I'm a mediator, and they will ask me, is there any good flat for sale? Is there any good plot of land for sale? Because in my jurisdiction, people call real estate dealers or brokers as mediators. So I used to get those queries. So then I had to clarify that I'm a dispute resolution specialist. So, I stopped using the word mediator. So even if you see in my LinkedIn profile, it will be digital dispute resolution specialist, because I don't want people to get confused and come with proposals of buying or selling land to me. Be that as it may. Now, what is mediation exactly? Now, if two people are having a disagreement between them, we usually find that the first step is to talk to each other, try to negotiate the disagreement and find a solution. Now, many times what happens is we are always looking at things from our point of view. So supposing, let's say that I have a disagreement with Vikash. I mean, he's a very sweet guy. Nobody can disagree with whatever he says. But Mr. Baby George, can you just mute your audio, sir? Yeah. So supposing I have a disagreement with Vikash. Now, what I do is I look at that disagreement only from my point of view, thinking that I'm right and Vikash is wrong. And Vikash also has the same point of view, where he thinks that he's right and I'm wrong. Now, what we do is we request a person like Atulji and tell him that, sir, look, we have this disagreement. Can you help us to come to an agreement? And Atulji says, fine, let's sit and talk about it. And then he asked me, Jawad, what is your perspective of this issue that is there between you and Vikash? And I explained to him my point of view. And then he speaks to Vikash and finds out his point of view. And then he asks me questions and he asks Vikash questions to help us to understand each other's perspective, and gradually leads us to come to an agreement that would be acceptable to Vikash and acceptable to me also. Now, the whole point of of this mediation is every dispute or every disagreement need not end in a loss for somebody and a win for someone. Both people who are in disagreement can always get something out of it. I'm consciously not using the word win-win because that's a very commonly used term for mediation. They say mediation is always a win-win prospect. Now, I don't look at it as a win-win prospect. I would rather say that I may not exactly win, but I will get something out of it, something that I can live with, something that would be acceptable to me. And Vikash also gets something which is acceptable to him, something that he can live with. And both of us are happy because it is something that we have decided. Now, one of the unique aspects of this is Atulji is not going to tell us what to do. He's not going to tell us that, look, Jawad, and look, Vikash, this is what you should be doing. This is what you, Jawad, you should be doing. This is what Vikash should be doing. He's not going to tell us that. But he's going to gradually take us to that stage where we understand each other's needs. And we say that, okay, this is something that we can agree upon, right? So this is basically what is mediation. Now, if you look at mediation from that perspective, as two people having a disagreement involving a third person to help them to reach an agreement, the scope becomes very wide. In order for you to go through the process of mediation, it is not necessary that you need to have a disagreement. Now, let's say that two people are trying to enter into an agreement. They are negotiating the terms of that agreement. Let's say to buy a property, for example, or to enter into a contract for developing something, maybe perhaps some property. Now, there also, I may come forward with my point of view and the other person may come forward with his point or her point of view. If a mediator comes there and helps us to formulate that agreement in such a way that we avoid any future disputes. Because now lawyers can play a very significant role there. I agree with that, because my lawyer is going to be advising me on how I can strengthen my position under the agreement that is going to come about, under the contract that I'm going to enter in. Now, Vikash's lawyer may tell him that, okay, these are the points that you need to safeguard your interests. Now, a mediator being a neutral person, because the mediator is not connected to me, not connected to Vikash. Now, the mediator comes there and helps us to understand that, okay, if you enter into a contract, now these are all the things that you need to take care of so that both your interests are protected. Okay. So the mediator facilitates the negotiation between Vikash and me in a more principled manner, rather than making it an adversarial process where I'm trying to get the largest piece of the cake or Vikash is trying to get the larger piece of the cake. Rather than allowing that to happen, the mediator says that, okay, let's have a principled negotiation between both of you. I will help you to negotiate. I'll help you to understand what is important for you and reach an agreement. So even before a dispute starts or a disagreement starts, we can have a mediation. There's nothing wrong with that. In fact, if companies understand the value of involving a mediator before they enter into a contract, I am sure that many disputes can be avoided in the future in the working of the contract. Now, that is one way mediation can play a role. The second way that mediation can play a role is when you have a disagreement. As I have already explained to you, what the mediator does. When Vikash and I have a disagreement, what does Atulji do in that? He helps us to understand each other's needs and interests, takes us beyond our positions. Because I am very angry, because I'm very upset with Vikash, because I feel that Vikash has caused some loss to me or has hurt me in some way, and this is what I want. I want to punish Vikash for that. Vikash has that same idea in his mind. But Atulji tells us that, okay, what is it that you're going to get out of this? How are you going to benefit out of this? What happens to your future relationship? How would you like to see your future relationship working on? Is there any benefit for you in continuing with your relationship? Or do you think it is best that you part ways amicably? What happens if you're not able to resolve this? Are you going to go to the court? How much is it going to cost you? How much pain and agony that you're going to undergo through all this process? So he helps us to understand what our real needs are and helps us to come to an agreement. Now, that agreement may not be the best thing. Okay, it may not be exactly what I want, but it is what I need. It is something that I can get without any violence. Litigation is violence. Because what happens in litigation? What happens when you go to the court? You use words which are very strong. Okay, you impute motives. You attribute blame. Okay, and you do so many other things there, which really go on to create a sort of a very negative, atmosphere, where the animosity between the two people who are involved in the dispute becomes more deeper. Whereas in mediation, we can avoid all that because the mediator recognizes the fact that I feel very strongly about this, respect my emotion. Whereas my emotions are not going to be respected in the court. How I feel about the dispute is not going to be discussed in the court, whereas the mediator is going to discuss that with me. So by just the mediator talking to me and asking me the right questions, I feel much more comfortable. Okay, I develop a trust with the mediator. I know that the mediator is a competent person and the mediator is neutral and she's going to do the best for me. Okay, so this is how mediation operates. So one is, before a conflict arises, you can go for mediation. You can go for mediation after a conflict arises. You can also go for mediation after the conflict arises and you have already gone to the court or for arbitration or for any other dispute resolution process. You can still go for mediation. Now, that is what happens in both court annexed mediation, where if you have a dispute, you have gone to the court already and the court tells you that, look, Baba, there's no point in you fighting over this. This is something that you can perhaps reach a negotiated agreement. And here is a mediator whom we have trained for this purpose. You go to this mediator and get your problem resolved. That is court annexed mediation. Now, what you do before you go to the court is private mediation. Now, as Atulji pointed out, the question arises, if before going to the court, I appoint a mediator and the mediator mediates the dispute and we are able to reach an agreement, what is the sanctity of that? Now, let's say that there has been a contract in which a dispute has arisen and the mediator mediates and we reach an agreement. Is that going to be another contract between us, which perhaps may lead to further disputes? If supposing the other party breaches that contract, should I then go and file an execution petition in the court? Not necessary. As Atulji pointed out, we have different mechanisms in which, unfortunately, today we don't have an act, the law. One of the main reasons why we want the law in place is because of the enforceability of a mediated settlement agreement. That is one of the reasons we need a law. Okay, so we don't have to call it as conciliation or we don't have to call it by any other name. Though, to borrow Shakespeare's words, a rose will smell as sweet by whatever name it may be called. So the question is, what do we do in the absence of a law? Now, Supreme Court also has come to a rescue. And in the very famous AFCON's case, which was rendered in 2010, the Supreme Court has said that mediation is akin to the Lok Adalat, which is constituted under the Legal Services Authorities Act. So we all know that an award of the Lok Adalat is like a court decree. So either you can treat a mediated settlement agreement, which is done privately, as a mediation done by a Lok Adalat. Of course, the mediator is not somebody who is a Lok Adalat constituted under the Legal Services Authorities Act. So perhaps there is a bit of a gray area there. But as Atulji pointed out, we have Part 3 of the Arbitration and Conciliation Act of 1996. Part 3 talks about the process of conciliation. Now, why is it called conciliation over there? And why are we talking about mediation? Are these two different processes? Seemingly, they seem to be two different processes, because wherever you see any of our Indian laws talking about mediation, they say mediation or conciliation, or mediation and conciliation. Whether you take the Companies Act, whether you take Section 89 of the Civil Procedure Code, which talks about court annex mediation, or any other, or even the Arbitration and Conciliation Act, if you see Section 30, it says that the arbitrator can refer the parties for mediation or conciliation. So these two are treated as two different processes. Now, one of the significant changes that may happen if the Act comes into force is that this difference is going to be obliterated. This difference is going to be removed. And mediation will be mediation, whether it is called as conciliation or any other name. So it will still be regarded as mediation. So the conditions are that, one, it should be a voluntary process. Parties should take part in it voluntarily. Number two, it should be a confidential process. Number three, the mediator should be a neutral third party who has no stake in the dispute. Number four, the parties have to determine the outcome of the mediation, whether they wish to settle or they don't wish to settle. And if they wish to settle, what is that they are settling about? It is left to the parties. The mediation process should be a without prejudice one. It should not affect the parties in any way if it fails. And it should be a completely confidential process. And the confidentiality operates at different levels. Any information that is shared between the parties, shared with the mediator, everything is covered by confidentiality. Now, if you see conciliation, all these parameters are there. Because how does a conciliation process start? You issue a notice to the other party saying that, as Varuna pointed out, saying that, look, we have a dispute. So why don't we have conciliation? Let's go for conciliation to resolve a dispute. Now, the other party has 30 days time after receiving the notice to say yes or to say no. And if within 30 days that other party does not respond to that, it is deemed to be no. So there is no conciliation. A similar provision exists in Commercial Courts Act also. Because you have to issue a notice to the defendant, inviting the defendant for mediation. If the defendant comes and takes part in the mediation, mediation takes place. So either you may reach a settlement, you may not reach a settlement. If the other party does not respond or refuses to come, you can go to the court under the Commercial Courts Act. Similarly, conciliation also. So if the other party comes, then the conciliator is appointed by mutual consent. Both parties can agree that, okay, so-and-so will be the conciliator for us. Conciliation process takes place. Now, in a conciliation, one of the significant departures from mediation as we understand, because if you remember, I had earlier told you that mediator does not tell the parties what to do, does not tell the parties how they should resolve the dispute, or does not tell them that, okay, this is the agreement that you should be entering into. Whereas the conciliator has the power to tell the parties that, okay, look, can this agreement be on this framework? Would you like to consider these terms to resolve your dispute? Now it is left to the parties to either accept that or to modify it or to reject it and come forward with their own. Whereas in mediation, the mediator does not even do that, does not even give the terms of settlement to the parties. So this is the essential difference between mediation and conciliation. So what the Supreme Court says is, if you want to do conciliation, you call it as conciliation and follow the process that is given in Part 3 of the Arbitration and Conciliation. If you don't follow the process, if you start it as a mediation, you cannot later on call it as a conciliation. So what we are now doing is, whenever we get two parties approach us saying that, can you mediate this dispute? We tell them that, look, we can treat this as a conciliation. So this is the process that we are going to follow. Okay. So we follow the process of mediation in the sense that whatever is required in mediation, I'll come to how the mediation process works also, so that you get to know what exactly, how exactly a mediator works, what happens in a mediation, what are the stages of mediation. We go through those stages, but we follow the process prescribed under the conciliation part 3 of the Arbitration and Conciliation Act. And when we reach an agreement, the parties sign the agreement and the conciliator authenticates the agreement. The conciliator does not sign the agreement, which means that the conciliator says that the parties came before me, conciliation took place, the parties reached an agreement, and this is the agreement that is enforced. So it conciliates, and it is deemed to be an arbitral award on agreed terms. So therefore, it has to be stamped like an arbitral award. So the judicial, non-judicial stamp paper that you use should be as per what is required under the arbitration for an arbitral award. So basically, it's an arbitral award on agreed terms. Now that, what happens is, is deemed to be like a decree of the court. It is executable. So if any party defaults, you can go and execute the arbitral award. That is the conciliation agreement, or for convenience sake, let us call it as an award on agreed terms, because that's what the statute also talks about. So there is an element of sanctity to the mediation process by simply changing the nomenclature and calling it as conciliation. So now one other aspect that I want to talk to you about is the stages of mediation. How does mediation work? It's a very scientifically designed process, because you are having two parties who are at loggerheads. They are not able to see eye to eye on a particular issue. And your hands as a mediator are tied because you're not supposed to tell them what they should be doing. So it was something like when I first started learning the mediation process, I recalled what went through my mind when I saw somebody cycling. When I started learning to cycle, I was wondering, there are two wheels, one in front of the other. And how are we supposed to sit there and balance and, pedal forward, and how are we supposed to move it? But when I learned the cycling process, like how do you cycle? And yes, you can balance yourself and you can pedal the cycle and it really moves. It was a kind of a revelation for me, because I realized that, okay, it's not really that difficult. So when you say that, in a mediation, you're not supposed to advise, you're not supposed to suggest, you're not supposed to tell the parties what to do, but yet you're supposed to help them to come to an agreement. It is somewhat like, how do you cycle? Okay, so that question comes to mind. Now, how this process works is, it is entirely based on the basic understanding of human psyche. Because mediation recognizes, first and foremost, that every dispute, every disagreement is between two people, two human beings who have feelings, who have emotions, who have their own way of looking at things, who are victims of their own perceptions. Okay. Perceptions are basically those filters through which we look at the world. Now, how I see the world may be completely different from how somebody else may be seeing the world. Or for that matter, even how my wife may be looking at the world. Or how my daughter looks at the world. It might be completely different. Because my perceptions are based on my own experiences, on the environment in which I grew up in, on what I was taught to believe in, and what somebody else looks at or understands or tries to understand the world is completely different, because their experiences, the value systems that they follow, their own beliefs, color their perception of what is happening. So mediation recognizes that people have a different way of looking at the same thing. No two people can look at the same incident, the same event may be perceived in two different ways by two different people, depending on where you're coming from, what your beliefs are, what your values are. So it is completely different. So mediation recognizes that. And mediation also recognizes that unless and until our feelings and emotions are addressed, there cannot be a holistic resolution of our problem, of our conflict. Because even if the external conflict may be resolved, the internal conflict may continue. So how do we bring about that? So what in mediation we do is we listen to the party, which is something we may not perhaps do as lawyers. Like I always ask people, what is the difference? Why do we call it as a court hearing? The court is hearing my matter. That's what we say. We don't say the court is listening to my matter. Why don't we say that? You hear a sound, but you listen to music. What is this difference between hearing and listening? Because when you're hearing only the facts and the law. When you're listening to the facts and you're listening to the emotions behind those facts. So you're listening to how the people are feeling about this, how the person who's talking to you is feeling about it. You're recognizing that, and you're showing the party, that the person who's talking to you, that you're understanding what that person is going through. And friends, believe me, that can have a very cathartic effect. We hardly listen to each other. Listening is a very emotional thing. A good listener cannot be a bad human being. If you're a good listener, you have to be a good human being, because only good people can listen. So we always say that mediation training is a life-changing experience, because when you get trained as a mediator, you basically get to understand and respect people, understand people for what they are, what they feel, where they are coming from. So unless you go to that essence of who this person is, how do you help that person to solve the problem? So the mediation process is structured in such a way that a mediator first makes an opening statement. In that opening statement, the mediator explains to the parties that, okay, this is the voluntary process. You're free to walk out of this anytime. So the very first act of showing respect is there, that I respect your autonomy to walk out from this. You're not bound to sit and listen to me. Can you do that in the court? Can you walk out of the court? You can't. You have no choice. You have to be there. But here you can walk out. So that is the first step to put you at ease, that I can walk out of this anytime I want. The second part of it is a confidential process. So whatever we discuss here is between us. The outside world is not going to know about it. Nobody is going to know about what we spoke. It's between us. So you can feel free to tell me anything that is important to you. And I'm not going to disclose it to anyone. And I'm not going to be judging you about it. Okay, so I will respect the confidentiality. The third thing that the mediator tells the people, parties, is this process is not going to cause any harm to you. If you reach an agreement, you have that agreement. If you don't reach an agreement, you're back to square one. You're back to where you started. So no harm is going to come to you through this process. The mediator lays down some rules. The mediator says that we are not bound by the law, though mediation operates under the shadow of the law. There is a distinction, but that will take a long time to explain. But let us understand this, that you cannot reach an agreement that is against the law. Okay? You cannot have a gambling agreement, for example, because it's prohibited by the law. So mediation operates under the shadow of the law, but in a mediation, you're not bound by any procedural formalities as to what can be discussed, whether this is barred by limitation, whether that is, acceptable or not. So all these questions don't come up. Okay? So it's all about what is important for the parties. But the two rules that mediators always prescribe are very basic housekeeping rules: uninterrupted listening to each other and polite conversation. Because we are sitting here to reach an agreement, and we cannot reach an agreement if we keep abusing each other or accusing each other. Okay? So if you're really upset, we can always have a private session where you can vent out all your emotions to me. And I'm here to listen to you. Okay? So we lay down the ground rules. And then, now what happens when people listen to you? And all the time you're smiling, you're looking at them, you're meeting their eyes, you're looking at their eyes, and you're talking to them, to both of them equally. You show your neutrality. You show that you're interested in them. You show that you care for them, and they begin to trust you. So the very first step towards trusting the mediator starts from the mediator. Then you listen to both the parties uninterrupted. You listen to them, and all the time you're asking them questions for clarification. You're summarizing what they're saying. You're reframing anything that may not be very positive, which may have some negative connotation. You're reframing that. Now, all these techniques you're using while you're listening to the people. And when you summarize and show them that you have understood what they're saying, now you're not confining yourself only to the facts and the law. You're also listening to their feelings. I can see that this situation has upset you a lot. And if I'm the speaker, I will feel very happy that here's somebody who's understanding what I feel about this. Right? So the trust develops more. Then the mediator sits with both the parties and says, okay, so from what I heard from you, I understood that these are the important issues that we need to be talking about, and we need to be finding a solution for. Once the parties agree that, okay, these are the issues that we need to be talking about. Now, there are different styles of mediation. There is what is called a shuttle mediation, where parties are taken into two different rooms. The mediator goes to one party and says, okay, this is what I heard from you, and this is important for you. So how would you like to see this resolved? Have you got any offers to make? Have you got any proposal? So the mediator listens to that, tests that proposal, finds out whether it is specific, finds out whether it has a value to it, whether it is something that is achievable, does all this, and then goes to the other party, listens to that party, and then exchanges the offers. Because sometimes what happens if you do this process jointly, people may start posturing. So they may not like to come out with the real offer, how they would like to really resolve, because they don't want the other party to think that they are talking from a position of weakness. So the mediator takes the burden on herself and keeps shuttling between both the parties, trying to get them into an alignment where the mediator is satisfied that, okay, now the parties are close, so now is the time to convey the offers. So you go and convey the offers. So in this manner, an agreement is brought about in a mediation process. Now, if the process is done effectively and parties sign the agreement after really understanding that, okay, this is the best thing that can happen to me, and this is the best that I can expect to get. Now, even if I go to court, it's going to take me so many years that it's a gamble. I may not get this. I might as well agree to this. Now, when they wholeheartedly agree to that, after understanding all the pros and cons, I have a simple question to ask. Why should they go back on that agreement? the very fact that it is their agreement, that they have signed voluntarily, gives it its own sanctity. If at all they commit a breach of that agreement, it may perhaps be because of some unforeseen circumstance, which they did not anticipate. Come back to the table again. Get the mediator involved, find a solution for that. So where is the question of executability or anything? A court's decree has to be executed for the simple reason because I am the defendant and I have not agreed to the decree. It is something that is forced on me. Whereas this is an agreement that I have signed, I have accepted. And I have realized, signed it after accepting that this is the best thing that can happen to me. This is the best outcome that I can expect. So that itself has its own sanctity. So why should I go back on that? So the question of executing that doesn't arise at all. Going to the court to get it executed or to enforce it doesn't arise at all. For the simple reason, because it's my agreement and I have thought about it. Mediator has helped me to understand what the pros and cons are. And I have come to a conclusion that this is the best that can happen. So why should I go back on that? So my firm belief is a good mediated settlement agreement is one which carries its own sanctity. It has its own value. People don't go back on their own agreements. They have agreed to it. So why should they go back? The question of enforcing something would come if they're compelled to go for mediation. If they're compelled to enter into an agreement. If something is suppressed from them and they're misled into entering into an agreement, and they come to know later that the information was not given to them, or some information was suppressed from them, or some misinformation was given to them. So when you make sure that the information that is exchanged is transparent, is correct. Now, supposing one person is relying upon a forged document and tells me in a private session that, look, I have this document, the person doesn't know that it is forged. I would tell this person that, okay, look, this is what we should do. In my view, this should be brought to the knowledge of the other person, but I cannot compel you to do that. If you're willing to do it, I can continue with the mediation. But if you're not willing to do it, it goes against my principles as a professional mediator to proceed with this mediation because the other person doesn't know that this is forged. And if you reach an agreement on the basis of a forged document, if tomorrow the person knows that my credibility is at stake, so I cannot be a party to this. Now I leave the choice to you. So this is what a mediator should be doing in mediation. Right? So where is the question of anybody going back on the agreement? Because it is their agreement, they have reached it after understanding all the pros and cons. Right? So that itself confers sanctity on the agreement. There's no question of enforcing. Because parties will honor the agreement, it is their agreement. Now, one very important aspect that Atulji also pointed out is who can be a mediator? The answer is a simple, anyone can. Anyone can be a mediator. Because if I'm exceeding my time, just give me 5 minutes more, I'll finish, okay?
We are in a private mediation, it is extended.
Thank you. So,
in fact, I will just share that Mr. Sen has also joined. We will ask him to chip in.
Yes. So I just wanted to say this and conclude that anybody can be a mediator. But the whole problem is, you may be a very good listener, you may be a very good negotiator. But if you are trained in that, okay, see, people are prodigies. Okay, many people can do many things on their own without getting trained, without knowing anything. They can do a lot of things on their own. But the problem is when some stumbling block comes, some obstacle comes, you don't know how to overcome that because you're not trained. You may be naturally talented. You may be very good in listening. You may be very good in negotiation. You may be very good in talking to people, empathizing with them and all that. But if you don't understand, if you don't have the process skills, then it becomes a challenge for you if you're faced with a situation which you don't know how to handle. So that is where the importance of getting trained as a mediator comes. It's a completely different mindset. When I used to be practicing litigation in the court, one of my trainers gave me a very simple mantra. She said, you are conducting an adversarial proceeding. You're fighting over there. You're blaming somebody, you're bashing up somebody verbally, you're doing also discrediting someone, you're doing all that. And now suddenly you're supposed to go and sit in a mediation, which is a completely different process. It operates on a completely different paradigm. How do you do that? She said, do a very simple exercise. Imagine that you're wearing the hat of a lawyer. Remove that hat, the imaginary hat, keep it down and say, I'm no longer a lawyer. I am now a mediator, and wear the mediator's hat, and then go and do it. Take some deep breaths, close your eyes and perhaps meditate for 5 minutes, calm yourself, and then go in a different frame of mind to do mediation. Now, I was finding that increasingly difficult for me, so therefore I decided no more litigation for me, let me do only mediations. And unfortunately, mediation doesn't provide enough money for me to look after my family, so I sometimes have to do arbitrations also. But I prefer to act as an arbitrator rather than be a lawyer in arbitration. So luckily, I get some work as an arbitrator. But the fact is, mediation requires a completely different mindset. You have to love people. You have to be interested in people. And whenever I do training, I tell my trainees that I follow a simple mantra. I say that mediation is a healing process and mediator is a healer. So basically, you're healing the conflict. So I'll stop here, friends. Thank you for your patience and for listening for such a long time. I hope I didn't ramble too much. And if I did, please forgive me for that. Thank you. Vikash, over to you.
I will ask requested Mr. Sen if he is still there.
Because your audio is not coming clear.
In fact, we didn't have the light, so I've logged in through the this thing. Yeah, I will see if Mr. Sen is there. I'll ask Mr. Sen to unmute him.
Thank you, Vikas. Vikas, I am in midst of my elections, but when Jawad sent me his, the flyer and said he was speaking, I couldn't resist myself. And it's always a pleasure to hear Jawad. And in fact, two things were raised. Varuna talked about court-annexed mediation and how beautifully Jawad explained you the entire process, so far as the process of mediation is concerned. Now, we are talking about sanctity and importance. Well, let's first understand what is the difference or commonality between the court-annexed mediation and private mediation. See, both have the same process. So far as the mediation part is concerned, the process is the same. Now, question is enforceability. Mr. Lakhanpal rightly pointed out, and Jawad concurred, that Part 3 of the Arbitration and Conciliation Act we use till the mediation law comes into being. When a private mediation happens, the settlement agreement, you see, if it is merely a settlement agreement, to enforce it, you will have to file a suit in case if there is a default. Jawad rightly said that 99% of the times that doesn't happen because you own the settlement. So there is no question of problem in enforcement. And to overcome that 1% chance, what we do, we use Chapter 3 of the Arbitration and Conciliation Act. And we convert the mediated settlement into a conciliation settlement. He's also beautifully explained to you the difference between mediation and conciliation. So once you have a conciliated settlement under section 74, it's a deemed award. Once it is a deemed award, it has the enforcement of a decree. So you can execute it. Now that is so far as enforcement is concerned. Now the only difference between private and court annexed mediation is in a court annexed mediation, the dispute has already landed in court. Now we are talking about dispute resolution or conflict resolution. Now what is a dispute? It's an injurious experience which goes through three phases, something which we call, see, I'm just giving you a little so that since I'm here and there are so many people hearing it, they can add value. I'm saying, adding value beyond what Jawad says is very difficult. But then I said, let me just add a few things about, every dispute goes through three phases. The first, this injurious experience. Like, look, let me tell you, every injurious experience need not become a dispute. You see, we may have difference of opinion, but it's not necessary that I may voice it to you so that, or we have a dialogue where we agree, these don't, agree with each other and ultimately land up in a situation where we stop talking to each other. It doesn't happen all the time. So every injurious experience need not become a dispute. Now, let me tell you now which are the three phases every dispute goes through. The first is the naming stage. When we feel that the grievance is unwanted, or we feel disvalued, and therefore we name the dispute. I'll give you an example. I may say, I don't like my job. Now I have named what kind of dispute or a grievance or an injury that I'm going through. The second phase is the blaming stage. When I blame a person because of which I don't like my job. So my boss, the same example, my boss gives me a lot of work and doesn't pay me enough. So that's the blaming stage. I blame some person. Then comes the claiming stage. And the claiming stage is when I demand from that person, please remedy it. And he refuses to remedy it. He says, look, you want to work with this much of money that I'm paying you? Fine, otherwise leave the job. Now, when we have gone through this NBC, we call it the NBC model, naming, blaming, claiming. Then we take this grievance to a lawyer, he converts it into a suit, and the suit lands up in court. So private mediation happens before the matter or the dispute actually lands up in court. Because we personally feel that every dispute need not land up in court. Courts are not supposed to decide every dispute. See, a neighbors, you have neighborhood disputes where dog is barking at night. You have the dog bit the neighbor's child. These can be resolved across the table. These disputes need not land up in court. And therefore, the importance of private mediation. Because there are several injurious experiences or disputes which we can resolve by using the services of a mediator who uses the process which has been explained by Jawad. And once you have a settlement, you make it enforceable by Part 3 of Arbitration and Conciliation Act. And all this till the Mediation Act, which is in the annual, comes into force. Once the Mediation Act comes, then probably the Act itself will provide for a machinery for both private and community mediation. I mean, because since we were party to that, so therefore these are the provisions which are already part of that Act. And I think in next 6 months, you should have the law. And I think it's Jawad's show. I think I've talked enough. Thank you.
Thank you, JP.
Thank you so much, JP.
I'm saying, first of all, we will wish him all the best for the elections so that
Yes.
we believe that he can take the mediation to the next level, though he's already taking that baton forward. Meanwhile, one question has come that let's assume there's a private mediation. What can be the enforceability in respect of the civil commercial ones? And in respect of a family matrimonial disputes, where arbitration clause or an agreement is not present? How do the parties of arbitration and conciliation come to the parties' rescue?
Yeah, I think that's on the chat, Vikash.
Yeah.
Atulji, shall I?
Yeah, please continue.
Yeah. So I think the question is, an agreement enjoys the same status and enforceability of a contract. What about the enforceability in case of mediations other than civil commercial ones? Okay, that is where I think I think the further question I think that has come about from Sangeeta Mehrotra is that, I mean, in a family or matrimonial dispute where arbitration clause or an agreement is not present, how the ANC Act comes to the parties' rescue. Now, there need not be an arbitration clause, Sangeeta, because Part 3 stands on its own footing. Part 3 does not require an arbitration clause to be there. If you look at Part 3, it says that if there is a dispute arising of a legal relationship between the parties, whether contractual or otherwise, the one party can issue a notice to the other party inviting that party for a conciliation. And if the other party agrees and comes forward, the conciliation can take place. Under 74 of the which comes under Part 3, the agreement that is reached between the parties, you have to read it with Section 30 of the Arbitration Conciliation Act, where it says that it will be deemed to be an arbitral award on agreed terms. So there doesn't have to be a separate arbitration clause for it to come under the purview of the arbitration and conciliation. I hope that is clear.
I think it's
Jawad, can I add to that?
Yes, please, JP. Please.
This is where Part 3 says, that's what we do. Instead of the person appointed as a mediator, the same person is appointed. There's a provision for appointing him as a conciliator.
Correct.
And so that settlement gets converted into a conciliation settlement.
Conciliation.
That's the only difference.
There are two hands up. I think Redmi, whoever that is, I think they.
Meanwhile, one has sent a private message. It says, what about a settlement in which there is a violation of law, which prohibits land transfer to non-tribals? That you have already taken.
Yeah, that I've already covered. I said it operates under the shadow of the law. So any agreement that is reached has to be a legally enforceable agreement.
Prajwal.
Prajwal.
Good evening, everyone. I'm Prajwal. I'm from Bhopal. And my question is, although Jawad sir, you have rightly pointed out the differences and similarities between mediation and conciliation, and how mediated agreements are treated as conciliation awards. What is your take on what will be the situation after the mediation bill gets into enforcement? What can be the difference? Because currently the major difference comes into the authority of the third party that is there, the conciliator or the mediator. What will be the situation after the act?
So if I remember right from the draft mediation bill, I think it is going to Part 3 may, I think, get repealed. Please correct me, Atulji or JP, if I'm wrong. I think Part 3 of the Arbitration Conciliation Act may stand repealed because mediation is going to cover all those aspects. So once you enter into a mediation, then the mediated settlement agreement will have the force of a decree of court. So it will become executive. So you don't have to worry about the difference between what is mediation, what is conciliation, because the definition of mediation will be covering all this, and one common nomenclature will be used to denote any collaborative process of dispute resolution.
Varuna has also raised the hand. Varuna?
Yeah, I just.
Varuna, you should be answering the questions.
I'm not questioning. I'm just trying. I'm just taking something forward.
Okay.
The student is always a good teacher.
So in private mediation, where the like, how does the mediator get an authority? It is only after the opening statement is made by the mediator, and the parties have responded to the notice sent, and they have come in with their counsels, and all of them are there. Only then, after the opening statement, when you ask them this question, that do you think this process will help you and will you like to participate? At that point of time, when they say yes, then the mediators enter into a tripartite agreement. And with that, in that agreement, he lays down the rules. And after the rules are accepted by the parties, the fees.
Varuna, if I may just interrupt you for a minute, I think you are absolutely right.
Openly in WhatsApp messages, I am supporting Jatan. And he still wants to be RO. मैं वही कह रहा हूँ ना, मनोज के लिए भी, मनोज जो ट्रेजरर के लिए खड़ा है.
JP, can you just mute the mic?
Fully support कर रहा है.
JP,
just 1 minute. Sorry, Jawad, I did not hear. I had a call on.
Yeah, that's okay. That's okay. No problem. See, Varuna, the thing is, what you are explaining is apt in a court annex mediation. Okay. But in a private mediation, there is even before the stage where the parties and the mediator get together, there is a process where the parties and the mediator enter into an agreement to mediate. So where the fees and all those aspects are discussed.
खुद आप तो support कर रहे हो दो candidate को और आप अब RO बनने के लिए agree कर रहे हो. You should be openly outside.
Just hold on, I will see.
वो अलग बात है, तभी मैं उसको कोई सुनता भी नहीं है, उसको लोग पागल कहते हैं. ज़्यादा आएगा.
Yeah, now you can start off.
So the private mediation process is different from that. It is not when the mediator makes the opening statement. It is much before that, because there is a process called convening the mediation. People call it as convening. Some other people call it as pre-mediation, because there are pre-mediation talks which are held between the mediator, the parties, in which perhaps the counsel may also be involved, where the venue is discussed, the timings are discussed, what is the duration of the mediation is discussed, what the mediator's fees are discussed. All this become the subject matter of an agreement to mediate.
Absolutely, absolutely.
Yeah. Varuna, I may add, whenever the parties agree that you act as a mediator, I think mediation process starts.
Yes, yes, please. Yes, please. The thing is that what I was trying to say is that I am not saying it is in the arena of post litigation or when you have gone to litigation. I am saying when in a mediation center there is a walk-in, or if there is in a court pre-litigation desk there is a walk-in, because all legal services authorities of every state has put in a desk in each and every court premises where they are getting the people directly there. So that is whether it is a institution in which a party comes and a notice is sent out by the institution. It may not be really a court. It is prior to the litigation has started.
Yeah. Pre-litigation mediation under the court annex program itself. That's what you're talking about, right?
No, Jawad sir, I am saying that there is a walk-in person. He comes with the problem to me and he says, Varuna, this is the problem. So I act like a kisok. I say, well, you can go for litigation, you can go for mediation, you can go for arbitration if there is a clause. But, well, these are the advantages and disadvantages. And then he says, okay, well, I will try for a mediation. Then a mediation notice is sent out, an invite is sent out from the taking assistance of the Arbitration and Conciliation Act, and the other side comes with their counsels on the within 30 days of the period. And when they come together on the given date, they sit together. Then the mediation process is explained.
Yeah.
And after that, they enter into a tripartite agreement with the rules.
Yeah, that is the agreement to be.
So yes. So
Yeah.
it will be convening of mediation after the notices have been sent out.
Correct.
That is what I.
Yeah. So I think there are two hands raised, Vikash. One is Red B.
That Red B is not. He's in the red. He's not unmuting himself.
Yeah, I think you'll have to unmute yourself, sir. And then there's Anil
But
Picha
Anil is
also.
not there.
No, you're muted still, sir. You're muted. Please unmute yourself.
Anil is also not unmuting himself.
I think we can come to Anil.
Hello.
And back to. Yeah, Anil, please go ahead.
I just want to respond to the discussion which is happening in the last stage, where mediation starts actually. With my very little experience, as you know, that I am just like a small baby in this field. Where mediator and the conflict meets, mediation starts. I just met somebody in Jaipur Secretariat last week. And I just said, there is a friend of mine in Jodhpur, and he says, I have a problem. And my mediation started.
Yeah.
The first thing which I told him that, why don't we resolve it? Why you have come up to this level to, Chief Minister office for a complaint? So I feel that the mediation starts where conflict and mediation meets anywhere in our life. And it is such a profound and a powerful thing. And one more thing, like, what the initial advocate, he said, that the judge asked that you must be threatening to the parties in the mediation. I think the biggest threat a mediator can give to the parties is, boss, resolve here or you will be in the court.
Exactly. Yeah, that's what Atulji also said. That's the only threat. I think Mr. Shantanu is here. Yeah.
Yeah. Hi. Good evening,
Good evening, sir. Your audio is not clear.
All the members here. I just had. Can you hear me now, please?
Yeah. Please go ahead.
Hello.
Yeah.
Am I audible now?
Go ahead. Please go ahead.
Yeah. So I just had one small doubt when I attended the session about last week, and we were talking of conciliation and mediation. One thing that came about as an observation there was that in a conciliation situation, the conciliator may make suggestions for a deal, and that deal cannot end the working relationship of the parties. Whereas in a mediation, it was observed that the deal can end a relationship.
Yeah, see, actually, see, the context in which that was told to you was about how it works on the international arena, how conciliation is understood in the UK and other countries. Okay, but in India, we have a separate Arbitration and Conciliation Act, Part 3. So that does not make this distinction between whether the relationship should end or should not end. That distinction is not there under our law. Okay.
Okay, so in both situations, the working relationship continues.
No, in India, in the Indian context, under the Indian law, the relationship may also come to an end if that is the agreement that parties are reaching.
Okay, got you. Okay, thank you.
Thank you.
Posted one question, Atulji.
Yeah, please. Which is the question? I have not got it.
It says, this is by Gaurav Kohli, if in a family cases, mediation, if the complainants withdraws their criminal cases against the accused husband and later husband doesn't apply the terms and conditions of those criminal cases, could it be reopened, or what will be the future course of action by the aggrieved party?
That is in fact a very tricky situation, because once you the mediator becomes defunct functus officio after you sign this agreement. But yes, if the parties back out and don't comply, then the remedy remains in the contempt or the restarting of all the litigation. That's it. this is going to be action are going to be taken in this regard for breach of any other contract that way. If Jawad can add something,
I think
this,
JP, would you like to clarify that? Yeah, you're on mute, JP.
Just checking it out. Which is same.
JP is more busy in his election, I suppose. It's gone away. What's he contesting for?
I think Vice President again.
Oh,
JPG, unmute. It's not responding. But there are certain cases. I remember that there was a case where there was a settlement, and ultimately 406, 498 settlement washed. Again, there was harassment. We went for a recalling. They rejected the case that it cannot be recalled. But if at all there is any grievance, you will have to move forward.
I think we also add one clause that if you don't abide by all these terms and conditions, status quo ante will be prevailing. So that way, I think we cover up some of these issues.
Yeah, Atulji, 1 minute. I think JP is not able to unmute himself. Vikash, can you?
It's very difficult for a person who's contesting an election that he can't be unmuted. I'm trying, but he's not unmuting himself. And that's what he was talking at that point of time. That
Yeah. JP, can you try now? Can you just?
No, it's fine.
His voice cannot be muted for long.
No, sorry, I was, in two minds because of that telephone call. Yeah, because you're right.
You will have to be in many minds.
And that you're telling us third. Very well. Okay, you know what? The answer to this has been given by a judgment of our own High Court. You see, a criminal case can't be reopened once it's quashed or is withdrawn.
What I was saying. In our case
So
also,
what we do, that judgment says that first the civil proceedings are completed, and finally, after all the terms are complied with, then the criminal proceedings are quashed.
No, the question is different. If they back up, what is the remedy with the person?
No, that's what I'm saying. That is given by a division bench of Justice Seema Kohli. It could be in the method of an undertaking to a court. If the person backs off, then an undertaking, he suffers contempt. In matrimonial disputes, the problem was 6 months, when there is a gap of 6 months, a person changes his mind. Statute provides for it, therefore you cannot do anything about it. Only thing that happens is the court asks for restitution. Whatever advantage you gained under the settlement, you have to return that. You cannot keep those.
JP, what we have been doing practically is that we add this clause that anybody who backs out from the terms of the conditions and doesn't act what as per the agreement is, status quo ante will prevail from the date.
No, so therefore the advantage taken by a party under the settlement has to be restored.
That's true. That's true. That has to be restored, but then some court has to order it.
No, but problem what was said was like what happens to the criminal cases. No, you see, criminal cases can't be restored. So usually what we do, the judgment or Delhi High Court judgment says, first you go through with the civil
cases and
then quash the criminal proceedings in the end, so that person does not back up. Once every other term is taken care of, has been executed.
Practically, JP, nobody is interested in civil cases in matrimonial matters. It is only the criminal matters which are
exactly
about.
That's right.
Once they finish off with the civil cases, they start the criminal litigation again.
That's true. But then that's what the settlement says. Once the settlement happens, criminal everything is over.
I think when we add these terms, I think it's quite a deterrent for the parties to back out.
Correct.
They probably feel that it can be started again.
We have realized that at the stage of writing, once you have even reached a settlement, at the stage of settlement writing, now see how many problems can come.
Yeah, that's true.
So therefore that's another problem. We know, therefore settlement writing itself is such a difficult art.
Correct. Of course it is. You have to fill in many holes there.
Correct. So therefore so that parties are not back in court again. It's so
JP,
important
which
to
election
write
are you
that.
contesting in for Vice President?
Yes, the vices don't seem to leave me.
Yeah, I think you have minor vices. That's why they don't leave you.
Thank you so much, guys. You guys continue. I'll take leave.
Okay, bye.
Thanks a lot for joining, JP.
Thank you.
Thank you.
Jawad, we will just take 2 minutes, two separate questions and then wrap up because some people have joined.
Sure,
late.
sure.
Now, how do you give the final 2 minutes, the sanctity of a private mediation and what is the procedure? And number 2 would be, once you said that, what is the difference between when we say, what is the difference between the hearing of a case?
Can you just come again, Vikash? I didn't get
First question is, what is the sanctity of a private mediation? What you have done in the entire 1.5 hours? So let's assume we have to take it in a clip in 2 minutes. Or how do you sum it up?
I think only Jawad, please continue.
Oh, okay. Sorry. You want me to sum that up, is it?
Yeah.
Yeah. My conclusion is that private mediation has its sanctity in the fact that it is the parties' agreement. And once it is the parties' agreement, they accept it as their own. Now, even assuming that in the outside chance that they may breach the agreement, as of now, since we don't have a law on mediation, we treat it as a conciliation, and that is where the status of an arbitral award on agreed terms is conferred upon the conciliation agreement that is reached, and that is executable in a court of law. Okay. The second point, what was the second point that you asked?
Second was, just for the benefit of the people, that why you said it is called the hearing of the case.
Yeah, hearing is you listen only to the facts of the case. You're not really concerned about how the parties feel about it. Like you hear the words, okay, you hear the law, you hear the facts, but you don't listen to what the parties would like to tell you. Where does the party get a chance to speak in the court? Even when the party is in the box, being examined as a witness, you're only asking questions and cross-examination, which are either yes or no questions, or you don't allow them to express whatever they want to say. If supposing a party says that, I was very hurt by what my brother said, you're going to respond saying that that's not relevant here. Whereas listening is something different. You listen to the emotion behind what is being told to you. So, for example, you hear the noise of a door closing. It is just a sound. You hear the sound. You listen to music because you're listening to the emotion behind that. Either the singer or the instrument that is being played, there's something more to it. There's more depth to that. So something which is more deeper than hearing is listening.
As I may add, the hearing is something, as Jawad has said. Listening is understanding what the man has to say.
Exactly. Because listening involves a lot of things. It's not just the words.
Yes.
Yeah, because when you're listening, you're also looking at how those words are being told. What is the tone of voice? What is the body language of the person? Whether that person is really meaning what he or she is talking about, or whether there's some other meaning that is being conveyed through that. Okay, I can even, unfortunately, we are online. I can't give a demonstration of that. But let us assume that somebody comes to your house, or I come to your house, Vikash, and you offer me a seat. And I sit over there, I'm very uncomfortable, I'm squirming in my seat. And you ask me, Jawad, are you comfortable? And I said, yeah, I'm fine. This is how I respond to you, because I don't want to offend you. You're my host. I'm a nice guy. So I tell you, yeah, I'm fine. Now, in another scenario, I come to your house, you offer me a seat, I'm very comfortable, I'm relaxed, and you ask me, Jawad, are you comfortable? I say, yeah, I'm fine. Now, in both the contexts, my words are the same. But when you look at my body language, in the first instance, I'm squirming, my face is getting distorted in different ways. I have different contortions on my face. If you don't notice that and take my words alone, you're going to be having a very uncomfortable guest here sitting before you. In the second instance, my words are the same, but my body language shows that I'm really comfortable. So that is what I mean by the distinction between listening and hearing, because when you listen beyond the words.
I think listening is understanding what the man is saying.
Exactly. Yeah. Very simple.
Yeah.
Varuna wants to say something.
Listen and silent are words with the same alphabets, but then it's the entire distinction.
Yes.
Like you have said that in the listening, you will have that silence and to understand the emotions.
Jawad sir, when I am explaining the sanctity of the settlement, mediation settlement in a private setup, I always say that it is of higher sanctity because Order 23 Rule 3 CPC says that it is a consent decree and the enforceability is of a higher degree. So it is like a consent decree. So it has much more weightage than just a like conciliation settlement. That is how I tell the parties that why this award, which we may say, but it is actually a consent decree.
Send some parties to us, we will tell them differently. Vikas, you have come to know that we are not working tomorrow, Hana?
I am in Surat tomorrow. I am going for a 40 hours training to Surat.
I'm just taking 2-3 questions with Mr. Jawad had taken up for the winding up part. Like you said that mediation is under the shadow of law. Could you explain that meaning for what do you mean by shadow of law if the mediation process goes under the...
Yeah, that's what I had told Vikas, that, you cannot reach an agreement in a mediation that is against the law. Like illicit cohabitation agreement cannot be reached, a gambling agreement cannot be reached, something that is prohibited by the law cannot be reached.
Any agreement, may I add, Jawad, any agreement against the law is void agreement.
It's a void agreement.
Under the contract act also.
Yeah.
Can't be any agreement against the law.
Any decision against the public policy cannot withstand.
Cannot be agreement. Yeah. Like
or
if you keep
any agreement which is dehors the law will have no judicial sanctity.
Precisely. Yeah.
Yeah. Now the third would be we have all believed that people feel that mediation is what people feel that it is a panchayati faisla. You feel that there is an importance of a training, and what are the benefits? I will take this question from all three.
Okay. Atulji, you want to go ahead?
Well, because these questions were there in our mind when we went for mediation.
I'm talking
Training.
about because we are taking session pan India so that people actually.
No. I'm telling you my personal experience only. When we were actually chosen up for this mediation training, we had the same things about this. What is this thing? Why are we wasting time but training does happen, and it happens to go for good. The trained mediator is always going to be far superior than the untrained mediator. Anybody can act as a mediator. Every lawyer tells us that he is a mediator. He mediates so many cases and so on. But everybody can run. But to be a professional runner, you have to have training. That's what my take is on training.
I'll put one liner to it. So when you are a trained mediator and a settlement is arrived at, they make an informed decision. The mediator helps the parties to reach an informed decision. While when you are standing on the road and deciding something, or you're sitting in a community hall and deciding something, people feel that they have lost something. They're losing on something to buy peace and harmony. They don't make an informed decision. So this would be, I would say, the training puts you to that pedestal when you assist the parties to reach an informed decision. Jawad, sir.
Well said, Varuna.
Well, I think that's very apt. See, the problem is, I think Gaurav has said that training kills the real instinct of an advocate. When in advocacy, we forget that we are advocate and not mediator. See, the thing is, instinctively, you may be a good cook, for example. Okay. Now, if somebody asks you to make biryani, you may just put a few ingredients together and accidentally the biryani may come out to taste very well. But it's a different matter if you're trained in that. Okay, because there the consistency will be there. Because every time you make biryani, it will be good for the simple reason that you're trained in that. Okay. So now it is, as I said, mediation is the healing process and mediator is the healer. Now, if you apply that concept, why do doctors need training? Why do surgeons need training? Why do we lawyers need training? We all get trained, right? Training is basically understanding how a process works and to apply those skills to the process. How we apply those skills, of course, we have the autonomy to decide what kind of skills to be used, when they are to be used, how those should be tweaked to suit the situation. But you need to understand that. Now, before I became a mediator, I did not know what was active listening. I did not know the principal negotiation concepts. I did not know that the mediation has to follow a particular process. There are different stages in mediation. I didn't know all these things. That is where training becomes important. Okay. Now, if I ask my 13-year-old grandson, ask him to drive the car, he may perhaps, because he plays a lot of video games and he knows how a car operates. But the problem is, unless he's trained, unless he goes to a driving school and gets trained in and learns how to drive, he will not know how to deal with situations that may come up all of a sudden. Okay, you may be instinctively, you may be very good at many things, but the problem is you need to understand. See, you can always defend yourself. Okay, anybody can defend himself or herself. But why do you need martial arts training to become an expert? So the idea is to become an expert. If you want to gain expertise, you need to undergo training. So without training, you cannot become an expert. You're bound to make mistakes. You're bound to do many things which are wrong because you simply don't know what needs to be done at what point of time. You don't know the process. So that is why I feel that training is important.
I did that. One Nitin Bansal has added that training polishes the natural instinct.
Exactly.
And ultimately, even from the medieval age and others, we will see that why it has been said that there's a distinction between a teacher and a guru. So they say that if you have a guru or a good trainer, like we have all been blissfully blessed that Mr. Jawad had trained all of us. And people are now blessed that we are on the online where Mr. Atul Lakhanpal, Varuna, Mr. Sain, they are all polishing in the right way. Polish is also an important. It is just like what in the cricket we say that if you polish the ball on one side, that it will start swinging in the same way. But for that, you also have to have a training in which side you have to polish the ball. That could be one way. Another is that I was reading what you said of biryani. I'm reminded that there's a session of Brian Tracy on YouTube as to why there is a necessity of training. And he also starts with that if you have a recipe, you start following it. First time you have to have a clean slate. Start following what the instructions are. But if you start following that, the natural instinct automatically feel. And after 5-10 times of practice, you need not look into the YouTube recipe or a recipe in a book. And your mind instinctively will take you that. So in a training also for a mediation, once you're trained in that aspect, automatically your sparks of the right sense will come into being. And I also believe that if you have read that book of James Clear on the atomic habits, it also says that 1% of change within your mindset will start giving you the right inclination. Suddenly you will not change, but once you start changing even 1%, then it automatically changes. It gives one example that let's assume you have one biscuit, start avoiding one biscuit daily. So by the end of the day, by the end of the year, it's one biscuit is of 10 calories. So you are saving 3,650 calories in a year. So that atomic habit ultimately converts into habit. I think that's good for today. We had many takeaways. We are indebted to Mr. Atul Lakhanpal, a senior advocate, Mr. Jawad, a senior mediator and a trainer, and a good friend of ours. And Varuna, as usual, chips in the right time. I'm reminded, just like Mahendra Singh Dhoni, coming with a helicopter shot and making you win. Same way, Varuna also chips in and gives the right sense. And who can forget Mr. Sain? We know that despite the tight schedule of our selection, but yet they say that you can take out a person's mediation, even if you try to take the mediation out, or who is a good trainer. He will squeeze in the time and come in. And that's what the hallmark of Mr. Sain is. So everyone stay safe, stay blessed. Namaskar.
Jawad, when are you making biryani now?
Sir, actually, we are having biryani today. I'm expecting some guests now.
And that's why he said the session should be at 5 rather than 6.
Yeah.
So he will be sharing the biryani today on the virtual platform.
I wish I could.
Thank
I
you.
have a secret to share here. I call Jawad that he is my Vikram and I'm the Vital. Anytime I'm stuck, I just, Vikram, where are you? And the Vikram appears, the Vital appears. Always changing the Vikram.
Okay. Bye, everyone.
She's undermining herself. No. Okay.
Bye.
Thank you, everyone. Thanks a
Bye,
lot.
bye, bye.